State of Wisconsin, Circuit Court, Branch 1, Manitowoc County. State of Wisconsin Plaintiff versus Stephen A. Avery, Defendant. Jury Trial, Voir dire, Day 1, Case Number 05CF381. Date, February 5, 2007. Before the Honorable Patrick L. Willis, Circuit Court Judge. Appearances. On behalf of the State of Wisconsin, Special Prosecutors Kenneth R. Kratz, Thomas J. Fallon. On behalf of the defendant, Attorneys at Law, Dean A. Strang, Jerome F. Buting. Stephen A. Avery, Defendant, appeared in person. Transcript of Proceedings. Index. Jurors. We will only be reading voir dire for the jurors and alternates that were actually chosen for the trial. Day 1 includes Daniel J. Slaby, Diane D. Free, Terry A. Tomei, Barbara A. Schmidt, Sharon A. Thorne, and Julie A. Dorn. The Court. At this time, the Court calls State of Wisconsin versus Stephen Avery. It's case number 05CF381. This proceeding is scheduled this morning for the beginning of individual voir dire for the jury panel members. Will the parties state their appearances for the record, please? Attorney Kratz. State appears by Calumet County District Attorney Ken Kratz and Assistant Attorney General Tom Fallon, both appearing as special prosecutors. Attorney Buting. Buting and Williams by Attorney Jerome Buting, appearing on behalf of Mr. Avery, who's present. Also, Dean Strang. The Court. Very well. I will note at the outset that no members of the jury panel are present in the courtroom at this time. The jurors are present, or the jurors who will be questioned this morning are present and assembled in the jury room. They will be brought into the courtroom one by one for individual voir dire. I would also note before we commence individual voir dire that the parties in this case have agreed to a jury selection process in which the questions normally asked by the court on general voir dire have been, in large part, replaced by a lengthy jury questionnaire completed by the members of the jury panel last week. The court in that questionnaire incorporated many, though not all, of the questions proposed by the parties for inclusion in the questionnaire. To assure that adequate instructions concerning the questions on the questionnaire were given to the jurors and that all questionnaires were completed, the administration of the questionnaires took place in the courtroom last week. The court was not actually in session while the questionnaires themselves were being completed. However, the court was in session to give the jurors instructions before the questionnaires were completed. At this time, I wish to confirm on the record that that process is acceptable to both parties in this case. Mr. Fallon? Attorney Fallon. Yes, Your Honor, that is acceptable. I don't know if this is the point, but we did have some questions regarding the time limits. But other than that, that process seems fine. The Court. Very well. Mr. Buting or Mr. Strang? Attorney Strang. As I recall, the part of this process that was acceptable to the defense is the special jury questionnaire substituting for the court's general voir dire questions. We were not happy with the lawyer's part of general voir dire being eliminated entirely by the questionnaire process. But we have no objection to the manner in which the administration of the questionnaire was handled, the distribution of it, and the jurors filling it out, outside of Mr. Avery's presence or counsel's presence. And we, too, will have the same objections to the court's proposed limit on individual voir dire. The Court. I understand you may have been unhappy, but I didn't understand that there was an objection made to the process as far as it's gone thus far. Attorney Strang. I don't know that we have ever been on the record about this, have we? And I don't mean to be saying anything different. The Court. I don't know if we've been on the record of it. I know it's been discussed. I was not under the impression that either party was going to make an objection to the procedure as it's gone this far, although I did understand that the parties Both were concerned about any time limits that the court placed on individual voir dire questions. Attorney Strang. Okay, the court. And I also understand that each of the parties, as I mentioned earlier, submitted questions that the court did not include on the questionnaire, which I assume the parties, if they wish, will follow up on in individual voir dire. Attorney Strang. Right. And again, I don't mean to be saying anything different than we have discussed off the record. I don't have any objection to the procedure as the court just described it. I do think I recall saying, and I thought Mr. Fallon was of the same mind, we were concerned about the lawyers not having any general, or maybe it was Mr. Gahn who joined in on this, any opportunity to address the panel as a whole. And that's all I meant to be saying just a moment ago. But I have no objection, again, to the court's portion of general voir dire having been committed to the questionnaire, and I understand that the court used some of our questions and not others of our questions, and I'm not objecting to that. So if there's been some miscommunication, I don't mean to be saying anything different than I have said off the record. The court. Well, I think it's important to know for the record whether or not there's any objection to the jury selection procedures that's taken place thus far. I thought, actually, the parties submitted written correspondence agreeing to this, but I don't have it committed to memory. Attorney Strang. And I don't, so much of this has been done off the record, I don't have it all committed to memory either. As a practical matter, provided we get adequate time for individual voir dire of jurors, there isn't going to be any great harm to Mr. Avery in not having had an opportunity to talk to the panel as a whole. And I understand that voir dire is a process committed largely to the court's discretion. So, I'm just trying to make a record of what I thought some months of conversations were. And I will stand corrected if it's my memory that has failed or I have not understood clearly. The court. All right, well, the court has been on the record, at least before the administration of the questionnaires, with the explanation of the procedure at that time. I'm not sure if the defendant is making an objection at this time to the use of the questionnaires to replace general voir dire or not, but at least I certainly, until this time, did not understand that there was an objection to any portion of the jury selection procedure to this point. Though I do understand that both parties wish to be heard today on the limit that the court has set for individual voir dire. That is, I wanted to limit each party to 15 minutes of individual voir dire with respect to each individual juror. As I have indicated to the parties earlier, the parties can request additional time if they feel it's necessary, depending on the answers given by any of the individual jurors to questions that are asked on individual voir dire. However, I would note that the information on the questionnaires themselves is far in excess of the information which is normally gleaned from general voir dire proceedings. Because of the size of the panel in this case, I questioned the efficacy of the normal process of general voir dire, where you ask jurors to raise their hands. Not only that, in many cases, when jurors don't raise their hands, the court doesn't know if they are just thinking about an answer or, because of social pressure, don't want to be the only ones to raise their hands. Whereas, when we give them a jury questionnaire, they have to answer every question. So I did feel in this case that the use of an extensive questionnaire was the most effective way to glean the information that the court would normally glean in the course of general voir dire. And at least to this point, I haven't understood that either party objected to that procedure. Attorney Strang. Why don't I take a moment with counsel for the state, off the record, just to see whether I'm the outlier in terms of, my recollection. The court. All right, we'll take a short break, go off the record. Brief recess taken. The court. All right, we're back on the record. Attorney Strang. That was helpful. Thank you for your indulgence, Your Honor. With Mr. Fallon's help, I remember now 2 conversations bearing on this one of which I can place as happening in the jury room, off the record, and the other I can't place at all. Although Mr. Fallon specifically recalls it being on one of our Friday afternoon off-the-record telephonic conferences in which he raised a concern about normally a supplemental jury questionnaire is exactly that. It supplements general voir dire, and I joined that concern. And then in the jury room, I think it was Mr. Gahn who inquired of the court, "Oh, does this mean we're not going to have a chance to talk to the panel as a group and to get some interaction, how one reacts to another's answer or experience?" And I chimed in on that, or I don't know if I started the conversation or Mr. Gahn chimed in, but he and I think, both spoke. And that led to a further discussion, apparently, about individual voir dire perhaps being a good solution to avoid losing a large panel if there was an inadvertent answer by one juror that would have represented a problem for the whole panel. And I think at that point some consensus developed that we could pursue the individual voir dire route and maybe accomplish most of what we need to. This was before the court had suggested a 10 or 15 minute time limit per side on individual voir dire. So I think the issues get linked. I mean, we're in a discretionary area where, the court has the discretion to deny the lawyer's questioning on general voir dire of the whole panel and to implement an individual voir dire procedure. But that procedure will have to be sufficient in the end to allow the parties two opportunities. One, to ascertain if there is a basis to move to strike a juror for cause, objective bias, subjective bias, or some other cause. And two, to allow the parties to exercise their preemptory strikes intelligently. And certainly, as to the accused at least, that's a right with constitutional footing under both Wisconsin and federal constitutions. Article 1, Section 7 and 8 of the Wisconsin Constitution and the 14th Amendment of the United States Constitution. So the two issues do become linked. There isn't any harm to Mr. Avery in the loss of general voir dire by the lawyers, provided that individual voir dire adequately makes up for the loss of general and allows those two critical purposes of voir dire to be accomplished in the end. The court. So do I take that to mean that the defendant has no objections to the conduct of the voir dire procedure to this point, but the defendant still is concerned about the length of time the court is allowing for individual voir dire and may object to the defense if the defense doesn't feel that time is enough? Attorney Strain. Yes. The court. Okay. Anything else from either of the parties on the voir dire procedure as it's been conducted to date? Attorney Fallon. Other than previously discussed? No. The court. All right. Now, do any party, either of the parties, wish to make comment at this time about the court's proposed procedure from this point forward? And just to reiterate for the record, as we discussed scheduling in this matter in the past, I indicated that because of the need both to get sufficient information on voir dire to allow the parties to intelligently exercise their preemptory strikes and evaluate the jury panel on the one hand, and on the other hand, to have voir dire conducted within a reasonable period of time, I did indicate to the parties previously that I thought that 15 minutes per juror on voir dire for each party, that 15 minutes worth of questions on individual voir dire for each party should be sufficient to enable each of the parties to consider the information gleaned on individual voir dire, in addition to the information on the jury questionnaires, to intelligently evaluate the jurors for their objectivity. As counsel has indicated in their comments, I believe both parties have concerns they wish to place on the record with respect to that ruling. Mr. Fallon, I will hear from you first. Attorney Fallon. Thank you, Your Honor. The state would take issue with a 15-minute time limit with respect to questioning the individual jurors. We realize it's been the court's prerogative to determine the procedure and the manner in which jury selection is conducted. But when the state submitted its proposed supplemental jury questionnaire on December 1st, the state was still, I believe, laboring under the impression that, first of all, that it would be a supplement to the general juror questionnaire, which every juror fills out and is in abbreviated form. I think we were unsure as to how much general voir dire, if any, would occur in the case. I agree with counsel's rendition. We did have a conference in chambers, I think it was in November, where this issue was brought up. And at that time, there was a discussion regarding general voir dire as counsel represented. And I think it might have been myself who said, well, there are some advantages to an individual voir dire to lessen the likelihood of any contamination of the panel as a whole by responses obtained from certain members, especially on questions regarding subjective bias. And I think the parties at that time were under the impression, and that I think argument carried the day, but at that time there was no time limit. We were not laboring under the impression that there would be any time limit to the individual voir dire. My second comment is that when the state submitted its questionnaire on December 1st and then did not hear any significant objection from the defense or the court, the state was under the impression that just about all the questions in its questionnaire would be asked or be part of the general questionnaire here. And not having any communications or any objections from the court or even concerns expressed by the court, and no objections from the defense, we were under the impression that those questions would be asked. And that, again, would I think have expedited, at least from the state's perspective, the follow-up time on individual voir dire. After all, that's the purpose of voir dire after the use of a supplemental juror questionnaire is to follow up on the answers. And since several questions were omitted, I may very well have 10 to, well, depending on the juror, 5 to 12 minutes per juror just asking the questions that were not included. And then I may have anywhere from no questions to 5 or 6 or 7 questions to follow up on the answers which are included. So, from that perspective, I am concerned that a time limit of 15 minutes per juror would be inadequate for us to flush out the potential of subjective or objective bias. I would state for the record, in my review, that I don't see any issues of statutory bias confronting us. But in terms of subjective bias and of 7 or 8 possible objective bias cases, it seems to me that the 15-minute time limit seems unreasonable, in all fairness to the court, and doesn't provide an ample opportunity to explore these two issues. So, as a result of which, we would ask leave of the court to be relieved from 15 minutes. Now, having said that, I fully acknowledge that there are several jurors here that I may have very few questions for, other than the ones I originally submitted in the jury questionnaire, which were not included, in which case 15 minutes may very well do the trick. There may be others that will take longer. So, from the state's perspective, we would ask the court be a little more patient with the parties. It's not like I foresee an hour per juror here like that. It's nothing, I don't see that happening in the case, but it just seems to me that 15 minutes would not allow us adequate time to explore these potential bias issues. So we would ask the court's indulgence to be more patient with the parties and provide a little more time to explore those issues. Thank you. The court. Mr. Strang, Attorney Strang. Thank you, Your Honor. Perhaps for the first time in this case, and I hope not for the last, I find myself entirely in agreement with Mr. Fallon's comments. All of it. I adopt it. And that's the defense position as well. I will amplify to this extent that I expect, too, that there may be some jurors as to which a 15-minute block of time would be adequate for the defense table to conduct individual voir dire, just as he is guessing that perhaps there are some for which 15 minutes would suffice for the state's questions. But it won't come as any surprise to the court that it also seems to me probable that when the state has fewer than 15 minutes of questioning, we may very well have more for any given juror, and vice versa. So I think the time limits are not sufficient to permit at least I will only speak for Mr. Avery here, both to ascertain accurately any reason to strike the juror for cause and intelligently to exercise his peremptory strikes, which you are limited to 7. They are not. Wisconsin doesn't sprinkle peremptory strikes generously, even in the most serious felony cases. So these have to be used wisely. And I don't think that the time limits the court proposes will allow that as to either of those 2 essential aspects of voir dire. The court. All right? I'm going to, at this point, use the 15 minutes as a guide. I'm not going to gong the attorneys if they get past that point, and I will monitor it. Obviously, since we haven't had any individual voir dire with any juror yet, the court cannot determine for certain whether or not 15 minutes is sufficient for the parties. I would like to confirm before we start, for the record, that both of the parties were given access to all the juror questionnaires that were completed by the jury panel last week, and the parties have provided to the court the identification of a number of jurors that they jointly are recommended to be excused for cause. The court has not formally ruled on those requests at this time, but I have used the parties' recommendations in establishing the order in which jurors are called in for individual questioning this morning. That is, passing over the jurors that the parties indicate that are individually recommending be stricken for cause. So that will affect the order in which the jurors are called in today. The court will make further rulings on the motions of the parties at a later time unless either party has any objection. Attorney Strang. No, and I certainly can confirm that the juror questionnaires were copied timely and completely by the clerk's office. And we had those late Monday afternoon, January 29th, just as promised. The court. Anything else from the state? Attorney Fallon. Nothing else, Your Honor. Attorney Strang. Should we note the sequence numbers of the jurors who were joint recommendation for excuse for cause? The court. I think that would be appropriate for the record. Actually, I have the email in front of me, so I can read it at this time. To save time, I will just use the numbers rather than the names. Its jurors numbered 1, 2, 9, 15, 16, 22, 29, 31, 40, 42, 43, 46, 48, 58, 62, 64, 80, 83, 84, 85, 88, 92, 94, 95, 99, 104, 108, 112, 116, 117, 124, 130, 141, 142, and 143. And I think the parties notified the court before we began today that they would indicate the general reasons for the joint recommendations. Mr. Fallon, were you going to address that? Attorney Fallon. Yes, Your Honor. Counsel and I, Mr. Strang and I, conversed by telephone late Thursday afternoon after our initial review of the proposed panels. It basically comes down to this. The vast majority of those excused are excused for cause based on our assessment of subjective bias under the statute. There were other jurors excused for economic hardship reasons. Primarily, they were the sole breadwinners in their home, and the potential of 6 weeks without adequate income would be an unfair hardship upon them. And finally, there was a smaller group of individuals who were excused for cause based on either physical or mental health reasons. And a fourth group included those who were a mix of subjective bias and either mental health or economic hardship. So those are the ones that we have agreed to on Thursday evening. There probably will be a few more during the course of the day as both counsel have reviewed the case law regarding objective and subjective bias. So there may be a few more sprinkled throughout the day that we would come to an agreement upon, but that's the status as of now. The court. Thank you. Mr. Strang? Attorney Strang. The court read the list of sequence numbers of excused jurors correctly. And again, I agree with Mr. Fallon's comments. The court certainly is welcome to include the email from which it just read in the record. And the format of that was that Mr. Fallon and I agreed, after our Thursday afternoon telephone call, that I would draft the proposed email to Your Honor, but send it only to Mr. Fallon. He would look at it to make sure that I hadn't loused it up. And if he was satisfied that I had done it correctly, he simply would forward it to the court. And that's what he did the following morning, Friday, February 2nd. The court. All right. I will print a clean copy of the email for the record, since I marked up the one I had. Is there anything else either party wishes to address before we bring in the first juror? Attorney Strang. One thing that I wish to address came up in chambers just this morning. Greg Conway of the Green Bay law firm of Liebman, Conway, Olenizak, and Jerry wrote to the court by fax on Friday, copied me, but I haven't seen that yet because I haven't been in my office. I moved up to this neck of the woods. Concerning 2 WFRV reporters and a letter they each received from bearing my signature stamp. And the short of it is that Mr. Conway is exactly right. When I had my secretary send out a merged letter to all of the people on the defense witness list, I didn't distinguish those very few who, in fact, were accepted from the exclusion order that the court entered. And both Anjanette Levy and Olga Haliburda, and for that matter, every other member of the media, are accepted from EXCEPTED, the exclusion, and they are free to sit in and watch the trial proceedings. And the mistake was simply that I sent the same letter to all defense witnesses. In fact, again, it was just my signature stamp, and then it enclosed a copy of the court's exclusion order. So the mistake is mine, and members of the media are not excluded or otherwise covered by the sequestration order. The court. Very well. Anything else? Attorney Fallon. We would agree with that. We don't have any problem with exempting them from the order. The court. All right. At this time, we'll have the first juror brought in. That will be Daniel Slaby, juror number 3. Mr. Slavey, before we begin, the clerk will administer an oath to you. If you would please stand and raise your right hand. Juror sworn. Just a quick aside here. The following instructions and information given to the potential jurors by Judge Willis prior to voir dire questioning is done with each jury pretty much verbatim after they have been sworn in. Therefore, I am only going to read it this one time in the interest of time and boredom. The clerk. Please be seated. The court. Mr. Slavey, like all the other members of the jury panel, you have already completed a jury questionnaire in this case. The next step in the voir dire proceedings is to give the opportunity of the attorneys for the parties to ask you some additional questions in order to make sure that you can be a fair and impartial juror. There are a couple of other pieces of information I wanted to pass on to you. Although I did not indicate it last week, while the trial in this case is expected to last approximately 6 weeks, the jurors will not be sequestered. That means the jurors will be permitted to return home after court proceedings every day. This decision is made possible by an assurance that the jurors will not read any news media accounts of the trial or talk to anyone else about it during the trial. So that will remain very important should you be selected as a juror. I also wanted you to know that although these proceedings are open, no cameras are permitted in the courtroom during voir dire proceedings, and the news media is not allowed to identify individual jurors by name in the news reports. And in addition, jurors who are selected to serve in the trial will not be on camera during the trial itself. If you are not stricken for cause following the proceedings this morning, You will receive further written instructions as to when to return to court. With that background, Mr. Fallon, you may begin your voir dire. Voir dire examination by Attorney Fallon. Good morning, Mr. Slavey. Good morning. I just have a few questions for you. Hopefully, they will be easy enough for you. We're not looking to embarrass anyone. We're just looking for some information to help us in selecting a jury. So, first of all, do you have any close friends or relatives who work in the media business? Newspapers, television, radio, internet? No, I don't. You do not, okay. Are you an individual, when you see a news story or you find something interesting in the news, do you use other sources to investigate the information behind the story? Like, for instance, some people go to libraries and check out books and read up on things, or magazines. Today, the most common item is the internet. Do you have a tendency to search out for the story behind the story, as it were? No, not usually. Okay, there is a possibility in this particular case that there may be some testimony from a co-defendant. Do you have any opinion as to the appropriateness of someone who is accused of a crime testifying against the other co-defendant in a case? No. In your day-to-day affairs, talking with people, in your work, or even in your personal relationships, if you find that someone has not been correct in providing you some information, insofar as it's inconsistent with something they previously said to you, or is inconsistent with something that someone else said, do you have a tendency to disregard that opinion on its face, or do you look further? Probably just disregard. All right, and so if you have a tendency to disregard, would you disregard everything that person told you, or just that particular opinion or viewpoint? Probably depends on the person. All right, and what are some of the things that you would look at in making that determination? I don't know what you're asking. Okay, well, what do you do for a living again? I'm a maintenance worker. All right, and if there's a snafu at the job, say one of your workers didn't conduct or perform a task up to appropriate standards, and they had told you that they did, and someone else or a few from your own knowledge realized that they had not. Do you have a tendency to disregard everything that person tells you or everything they do? Or do you look at other factors in determining that person's credibility? Probably just disregard. Okay. Have you or anyone close to you ever been in charge of writing any safety guidelines for setting up or enforcing safety standards in your work? No. Okay. In your line of work or in any previous job, have you ever been required to conduct any internal investigations or follow up on any behavior or activities of fellow employees? No. Okay. How long have you been a resident of Manitowoc County? My whole life. All right. In general, how would you rate the job that the Sheriff's Department is doing in dealing with crime, as well as the public at large? Would you say they're doing an excellent job, a good job, a fair job, or a lousy job? I would say fair job. Okay, and what causes you to say they have been doing a fair job? I have nothing to suggest that they are doing a poor job. All right. You're just a tough grader? I don't really have a positive or negative opinion on it. Okay, in terms of your general impression, when a police officer testifies in court, in your mind, how likely is it that he or she would lie under oath? Very likely, somewhat likely, not very likely, or not very likely at all? Not very likely. Okay, and why would you say that? Just that he is under oath and probably doing his or her job. Okay, in your mind, how likely is it that a law enforcement agency would conspire to convict an innocent person? Very likely, somewhat likely, not very likely, Not at all likely. Not very likely. And why would you say that? I really don't know what they would gain from it. Okay. In your mind, how likely is it that a law enforcement agency would plant or tamper with evidence to secure an arrest and or a conviction? Very likely, somewhat likely, not very likely, not at all likely. Not very likely. Okay, again, any particular reason why you have that general opinion? Same reason. All right. In your job as a maintenance professional, do you use industrial solvents or cleaning products such as bleach and things of that sort to help you perform your job? Very few chemicals. Okay, what kind of work, maintenance work, exactly do you do? Well, building maintenance, plant maintenance. We do some cleaning, just a wide variety, something different every day. Okay, so you don't actually have to do real cleaning or anything. You're kind of the handyman, fixer-upper? Right. Okay, all right. I noticed you brought a couple of books in. Do you like to read? I usually don't have time to read. In your spare time, do you like to work on puzzles, or do you just hate doing puzzles? I'm not a puzzle person. Not a puzzle person. Okay, generally, what kind of books do you like to read? Outdoor adventure, maybe. Okay. Have you ever seen the movie A Thin Blue Line? No, I haven't. Okay. Would you consider yourself more of a detail-oriented person, or are you a big picture guy? Probably a big picture person. Okay. Have you ever used a magazine publication such as Auto Trader or anything like that to sell a vehicle or purchase a vehicle or anything like that? No. Never used the internet to buy or sell? Ever try that? I probably looked on the internet when I was looking to buy a vehicle. Okay, all right. Have you ever read or heard anything regarding Project Innocence here in Wisconsin? I probably never read anything about it. All right. Have you heard anything about it? Probably with this story is the only time I've ever heard of it. Okay. Any opinions on the project or the idea behind it or anything like that? Good idea? Bad idea? It's probably a good idea. Okay. Generally, do you think the criminal justice system is either too lenient or too harsh when it deals with those accused of a crime? Do you have any opinion? Too harsh, too lenient, just right? I think it's fair. Okay. Now, I note from your questionnaire, on one of the questions you were asked, have you ever known anyone who was killed accidentally or otherwise? You indicated your wife's cousin was killed in a fire, apparently relatively recently? Yes, it was in the fall. In the fall? Okay. Can you tell us a little bit about that? Was it an accidental fire, or was the fire intentionally set? It was an accidental fire. Okay, so there hasn't been any litigation or any investigation regarding that fire? No. Okay. You also indicated in your questionnaire that you have some prior jury experience. Overall, was that a good experience? Yes. Was there anything about that experience that makes you wonder whether you could sit through the process as a juror again and evaluate the facts and deliberate and anything about it? I don't think it would be a problem. Okay, that's all I have. The court. All right, Mr. Strang? Attorney Strang. Sure, thanks. Voir dire examination by Attorney Strang. This is really an awkward way to talk to someone, but try to let me feel awkward and you not. All right? How do I pronounce your name? Slavey. Okay, that's how you pronounce your name? Right. I hear it different ways, but okay, I'm going to try to do it the way you do. We hear it different ways, but Slaby is how? Slavey. Right. So, how long have you worked at Manitowoc Eyes? A little over 4 years. At Red Arrow, I have your questionnaire. At Red Arrow and Miro, were those longer periods of time? Red Arrow was brief, but I worked at Miro for 12 years. Same kind of stuff? Maintenance, yes. And so how does a big picture guy, who is not really a detailed guy, how do you get drawn into maintenance? Well, it was just something that always interested me, fixing things, building things, since I was a kid, so that makes sense. Cars too, or I worked on cars when I was younger. See, part of what I'm interested in is you're not a TV watcher, or not much I'm gathering, so what do you do when you have spare time? I remodeled my home. For the last 3 years, that's what I've been doing. You guys own your home? Yes, the TV watchers. I work second shift, so like 4 to midnight? I work like 2:30 to midnight, so I'm busy all day, so, right, that sort of explains that. Right. When do you see the daughters? I see them in the morning before I go to school. Sort of design your sleep schedule around, right. Being able to do that, right. Are you a Monday to Friday guy, or do you wind up weekends too? I work a lot of Saturdays too. Just 'cause that's the schedule at Manitowoc Ice. It's overtime, voluntary overtime. I work quite a bit of overtime too. It sounds like your wife also has a full-time job you didn't say that, but that's what I read into your description of her job. Yes, she works full-time. So what you told us was that the radio maybe was the most common way you have gotten some news about this case? I would think the radio. I will have the local radio on in the morning. To and from work, or while you guys are usually having breakfast? On my way to take my daughters to school. So you pick up snatches of this because it's, right, local news? Do you read the paper? No, I don't. Do you guys get the paper? No, we don't get the paper. Yeah, okay. So what do you know about Brendan Dassey? Well, I know that he's the nephew, and he's also charged in this case. Yeah, actually, not right in front of this judge. Right, but he's charged here in the same county. Yes. Have you followed at all, what's gone on in his case? Not recently. When did you last track that or hear about it? It's probably been 2 months, 3 months maybe. What was it? I can't even recall the last time I heard a thing about him. The nephew, okay. Right. Do you remember what it was you heard? No, probably just the name came up. How many guys do you work with? Like side by side at work, or are you off on your own for most of the time at work? It's myself and 2 other mechanics. And you guys tend to be teamed up, or we're usually on our own? Okay. So how much sort of, gas bagging at work or yakking about this case have you overheard? I don't know I couldn't really put a time on it. Well, no, and I'm not really asking you to do that. Nobody could do that. But has this case been a source of, or subject to some chitty chat at work, or, are you guys talking about ice fishing or the Packers or something else? Well, we talk about a lot of things, so I'm sure the case has come up. We talked about it. What do you know about the statements that Brendan Dassey supposedly made? I think I did see the news conference when it first came out. I did watch that. The one that Mr. Kratz? Yes. Okay. Yes. Do you remember 1, 2? It's been a while. But do you remember anything about that news conference? I couldn't remember most of it, probably. I couldn't repeat it, but I remember the sort of gist of it? Yeah, if you want to call it that. Did it curl your hair? That news was pretty shocking stuff. It was pretty graphic, yes. So, how does somebody with a 17-year-old daughter react to that? Well, it like you said, it made my hair curl. Disturbing is what it was. Yeah, so here I'm representing the guy who didn't make all those statements. The guy the news conference wasn't directly about, but, did this get linked to Stephen Avery in your head? Or, did you see this? That press conference as being about more than Brendan Dassey? Can you just tell me about that? Sure it did, because I believe they were talking about Stephen Avery in the story too. Both names were mentioned. Okay, of course, at that time, you're not sitting there thinking, gee, I may be a possible juror someday. No. But, you have had college. You not only graduated from high school, it looks like you had technical college, yes. Yeah, you've gone to school beyond high school? Yes. So, you know that in our country, someone is presumed innocent unless and until the state can prove them guilty beyond a reasonable doubt? Yes. And that's stuff you've heard, I assume. Yes. Do you buy into that? Do you take that to heart? Yes, I do. So how, if you were sitting in Stephen Avery's chair, knowing that you're possibly going to be judging you, if you're sitting in this chair, you had seen this news conference and it's about Brendan and Stephen, would you want you as a juror, would you view you as someone who can say, yeah, I can put that aside. I assume they got the wrong guys here. Attorney Fallon: Your Honor, I'm sorry. I have to object to that. Asking the juror to put themselves in the shoes of the defendant, I think, is an improper question. The court: Why don't you try and rephrase that, Mr. Strang? Do you think, as you sit here today, do you presume that they got the wrong guy? Answer: I believe that. Attorney Fallon: I'm going to have to object. That's not the standard. The court: I'm going to sustain the objection. Attorney Strang: Okay, I think it is. I'm trying to get at, do you presume him innocent, which would mean he didn't do it? Attorney Fallon: No, I have to object. The court: I'm going to sustain the objection again. Question: Does the news conference make you tend to think that maybe he is guilty? I believe that he's innocent until proven guilty in the court. That's what I believe. And again, look, you're under oath. Obviously, you're doing your best. There really are no wrong answers here. There really aren't, as long as they're truthful. I'm just trying to get at, whether this is something you can do. And you have told me you believe he's innocent unless these folks can prove him guilty. Yes, that's what I believe. And what I'm trying to get at is that, do you believe that in your gut, or is that something that you know? That's the way our system works. That this is a great country. It's one of the freedoms we have, or the protections we have as citizens. Sort of at what level do you believe that? In other words, is that a big picture belief, or is that a detailed belief as to this case? I'm just going to say that I believe that he's innocent until proven guilty. The two other cases on which you were a juror, you actually sat on both those. You were one of 12? Yes. Okay. Have you been called for jury duty any other times? No, this is my third time. Third time being called as a juror. And were the other two cases, were they both here in Manitowoc County, or was one of them federal? They were both here. In this courthouse? Yes. So, actually, you have never been kicked off or not selected as a juror. One of the times I was kicked off on one of the trials, but I was called the 2 times previous, and I did sit on trials both times. Yeah, okay. and kicked off his, you know what I mean. I mean, you were one of the big group, but not one of the 12? I did get, yes. One time, okay. And you were not the foreperson either time, right? What do you mean? You weren't the foreman of the jury? No. Either time? No, I wasn't. Do you remember anything about the criminal case you were on? Yes. What the guy was charged with? He was charged with driving without a license. Okay, and you all found him guilty? Yes, we did. Did you go into that one saying, hey, I presume this guy's innocent, and I'm going to wait and see whether they can prove to me, beyond a reasonable doubt, that he did it? Yes. And was your experience pretty good with the rest of the jurors doing that? Yes. Didn't have to say, hey, wait a minute, we've got some instructions here. You guys ought to follow these. No. Did the guy who was on trial that time for operating, was it without a license or? Right. After suspension or something, did he testify? Yes, he did. Should someone do that if they're on trial? He was acting as his own lawyer. Therefore, had a fool for a client? Right. But, do you think someone ought to do that whether they are representing themselves or they have a lawyer? If they're accused of a crime and you didn't do it? What's your view about whether they should or shouldn't testify? I would think that it would help the case if he did testify. Tell me about that. I believe that it gives you a chance to prove your innocence. Because you have the right to testify? Right. And you say it helps. Did it help you as a juror, to hear that? Yes. A lot of us, fair-minded people, often say, I want to hear both sides of the story. I don't want to make up my mind until I hear both sides. Is that something? Right. The way you approach the world, too? Right. So, what if I don't recall Mr. Avery as what if I don't call Mr. Avery as a witness? I don't know if I will or won't, but what if I don't? How does that affect the way you look at the case? I don't really know what that would do. You're going to hear in this case, if you wind up on the jury, you're going to hear that he was convicted once before in Manitowoc County of a crime it turned out he really didn't commit. Have you heard anything about that? Yes. The Innocence Project stuff? Yes. And first of all, do you have any questions about whether he did or didn't commit that 198? It was in 1985. The 1985 charges? No, I don't have any questions. That is, when the state crime lab did new DNA testing and said it wasn't him. It was another guy. You haven't had any reservations about that, or have you? Well, I believe it was a shame that it happened. Right, but you haven't said, I bet he's guilty anyway? No. And you find out that he did testify in that case, in his own behalf, and got convicted anyway. And do you understand why that experience might make him, in particular, a little bit reluctant about testifying in his own behalf again? Attorney Fallon, I will let it go. Yes. Question. Why else might someone who is not guilty decide not to testify in his own behalf? He might not want to speak in front of people like me. I was going to say, why does that one come to mind first? Well, yeah, that's absolutely. The guy you had on your prior criminal jury didn't have a lawyer. Would lawyers enter into that? Our advice or our views? Sure. As to what he might do? Yes. What other reasons might someone just decide, no, I'm going to rely on my presumption of innocence. I'm not going to take the witness stand. That's also his right. That's true. And I take it you don't have any beef with the law in that respect? No. Okay. We have asked you, both of us have asked you a little bit about, Mr. Fallon called him the co-defendant. I'm calling him by his name, Brendan Dassey, and his statements, or at least the news conference that you heard. Have you ever had an experience or read about something, had this touch you, where somebody admitted doing something he actually did not do, or she actually did not do? I mean, one of your kids ever done that, for example, when they were little? Fessed up to something they hadn't done? Usually the other way around. Yes, it's usually the other way around, but do you think it's possible that people can, under the right or wrong circumstances, admit doing something they really didn't do? I guess it's possible. I know I can't give you names or anything, but I'm aware of an occasional circumstance where maybe there's a high publicity crime and somebody who is a couple bubbles off plumb comes forward to the police and says he did it for the attention, sort of an attention-seeking, weird motive. Have you heard of that sort of thing? Yes. But when you hear a prosecutor or a witness, police officer, somebody saying somebody confessed or admitted their involvement, what's your first reaction to the power of that? I guess I would want to believe it. Why? Because of who it's coming from, meaning the police officer or whoever is telling us. Right, yeah. And they might well believe it. I mean, you would assume that they believe it. But what about the actual person who supposedly made this statement himself? Do you think, what I'm getting at is this, are you saying, well, if he admitted it, game over. Nobody would admit killing someone if they hadn't really done it. Or are you somebody who says, geez, does that make sense? I wonder if he really did do what he's claiming he did. It didn't make sense at the time I heard it. Okay, on your questionnaire, there was this question that asked you, I don't expect you to remember this, and I can't remember the exact language of it either, but there's a question that says, look, you're going to be told, in deciding which witnesses to believe, that a law enforcement officer is just like every other witness, got to consider the same things in deciding how much weight to give his or her testimony, just like you would any other witness under the sun. And you answered, yes, you could follow that sort of instruction. Yes, you could live with that. And then Mr. Fallon followed up a little on that and asked you to rank or rate how likely it was that a law enforcement officer would not tell the truth on the stand. And I want to pick up from there with you. How likely is it that any witness who's sworn under oath, would lie on the witness stand? Not very likely. And I don't want to put words in your mouth, but the way you look at the world, you say, for most people an oath means something. Yes, I believe that. And do you agree that there are probably some people out there who just don't care about an oath and would lie in spite of having sworn? Yes, I'm sure that happens. But you're saying most people, at least, the oath matters to them. Yes. Is there any reason that the oath should matter more to a police officer as opposed to, a truck driver, school bus driver, a homemaker, or anybody else? It shouldn't matter. What the job is, you mean? Right. Go back now. I'm just sort of going through the questionnaire a little bit. But going back to the jury service. And you were asked after you told us about what juries and when and what kind of case. You were asked how you felt about that service. And you wrote, I had no negative feelings about serving as a juror. I'm curious about that. About why? Because, I know it's inconvenient at best. Sometimes it costs people money in terms of lost income. How come you had no negative feelings about serving as a juror? I thought it was an interesting process, and I thought it was fair. Fair to whom? Fair to the suspect. Yeah, but how about fair to you? Is what I'm wondering. It was fair to me. I didn't have any objections to serving. And I didn't ask you how long the civil case went. Do you remember about how long a trial that was? I think that was like a week, 5 days, something like that. And the guy represented himself and the operating without a license case had to be 1-2 days at most. That was a 1 day. So if you wind up on this jury and you wind up having to come and go, to Chilton for 6 weeks, how's that going to affect you at work? Or, I'm not trying to pry into your home finances, but how is that going to affect you with all the hats you wear? Dad, employee, husband, member of your union, member of your church. How's that going to affect you? It won't affect me at work. They'll be cool about it. Well, I'll be paid for jury service. Okay, and other stuff. Can you fit this into your life? It's an inconvenience, but I can fit it in. Have I asked anything, or for that matter, did Mr. Fallon ask anything that, caused you to think of some other issue you should bring up with us, or something to the court, or both sides should know about? You're getting into this 6-week project. If you do. No. Attorney Strang. Okay, thanks. I'm good. The court. All right, thank you, Mr. Slavey. Linda will now escort you out from the courtroom. Counsel, does either party have any motion with respect to this juror? Attorney Fallon. There is no motion from the state. The court. Mr. Strang? Nope, no motion here. The court. Very well. That juror will be considered on the panel. At this time, we're going to take a break. Let's make it a 7-minute break. We'll come back at 10:30 and resume with the next juror. Brief recess taken.